This is the special edition of the KhoodeelaarTV television channel. And this one is calling on Helen MacDonald and all her supporters in England to immediately file county court applications in their own areas, citing the 1998 Human Rights Act and claiming that the human rights of Helen MacDonald are being and have been violated, and those violations are being perpetrated by keeping a murderous sentence on Geronimo. I'll go into details as to how to file the applications under the county courts, because in terms of costs, an application to the county court doesn't cost too much. So it should be within the means of many of the dedicated supporters for keeping Geronimo free from harm by the DEFRA. So look up the 1998 Human Rights Act and you will find that it provides for the protection of human rights of the individual. And Helen can make the application under the 1998 Act. And this is economical in terms of time, in terms of resource, and in terms of expedition, because the application can be filed tomorrow, but the notice can be communicated to the court clerks by emails today, this evening, by each of the applicants, including by Helen herself. And the intention to apply under the 1998 Act, plus other human rights provisions, can be stated briefly in the emails. It's very simple, and the costs are, I'm going to check all of this in this particular broadcast, and you can rewind and you can see what I'm saying. If you miss it while it is on, you can go back after the broadcast is finished and you can see what I'm saying. And this is the what this will do. The mass applications to the county courts will serve as a better and bigger pressure on the state apparatus than any of the pleas that are being ignored by George Eustace and his colluders in DEFRA and by Boris Johnson. You can make any number of pleas to Boris Johnson and Eustace, but they are ignoring. They're determined to murder Geronimo. So our purpose in applying under the 1998 Human Rights Act is to protect Helen's human rights, because they have been violated. They are being violated, and they have been violated for too long. And she has been denied her human rights, despite the fact that her human rights are absolutely enshrined in UK statute, UK Act of Parliament. So the Human Rights Act, I'm going to look first. And this is the 1998 Human Rights Act. And you just type on the search on Google. And this is Human Rights Act 1998, UK Public General Acts. And this is one of the public acts. And it has got four schedules. And you can look up and you can find everything. And so let's read the introduction. The Convention writes, In this act, the convention rights means the rights of fundamental freedoms set out in the Articles 2 to 12 and 14 of the convention. Articles 1 to 13 of the first protocol and Article 1 of the 13th protocol, as read with Articles 16 to 18 of the convention. Those articles are to have effect for the purpose of this act, subject to any designated derogation or reservation as to which reservation the article set out in Schedule 1, etc., etc. So what we'll do, go to the interpretation of convention rights. A court or tribunal determining a question which has arisen in connection with the convention right must take into account any judgment, decision, declaration, or advisory opinion of the European Court of Human Rights. And 2, that is B, opinion of the Commission given in a report adopted under the Article 31 of the Convention. And then it goes to C, decision of the Commission, etc., etc. Evidence of any judgment, declaration, or opinion of which account may have to be taken under this section is to be given in the proceedings before any court or tribunal in such a manner as may be provided by the rules. In this section, rules means rules of court, or in the case of proceedings before a tribunal, rules made for the purpose of this section. Okay, so there is no derogation that applies. Derogation means that the UK's compliance with the convention, the international convention, that is Human Rights Convention, UK's compliance, duty to comply, can be excused on 2 grounds. One is that to comply would undermine the UK's national security or would undermine some domestic issues that affects the safety and security of people and animals and the environment, etc., etc. None of those grounds for derogation applies in Helen's case because she is not a threat. She's only exercising, she's only applying to exercise her rights as enshrined in the Human Rights Act 1998. And there is no ground on which the Crown can intervene. There is no ground in this case that the Crown, that is the government. Okay, so let's read the acts of public authorities. This is on the website. It's Human Rights Act 1998. And here is the brief definition. Acts of public authorities. It is unlawful for a public authority to act in a way which is incompatible with the human right. Subsection 1 does not apply to an act if, as the result of one or more provisions of primary legislation, the authority could not have acted differently. Well, in this case, they have been violating this. They could have acted differently. They could have provided the information. They should provide the information that Helen has been denied, despite the fact that for 4 years she has been requesting, in effect, the same information that she is entitled to. And the fact that she is impacted by the utterances and the particular set of decisions that have been made so far through the courts is evident in her expression of the fact that usually she doesn't cry, she doesn't shed tears, but she has been weeping and crying since yesterday. In the case of one or more provisions of or made under primary legislation which cannot be read or given effect in a way which is compatible with the conventional rights, the authority was acting so as to give effect to or enforce those provisions. This does not apply because, far from trying to comply with the convention and give effect to the convention provisions, DEFRA has been trying to deny and deprive and suppress them. And the definition of public authority includes a court or a tribunal. And here, the behavior of Mary Stacy comes under this category. She has violated the 1998 Human Rights Act, and that should be included as a ground. Any person, certain of whose functions are functions of a public nature. George Eustace and the chief bat and anyone else who has been colluding, anyone else who has been complicit in the making of these statements, false statements, through the press office of the DEFRA and other kind of contacts and communications to the media and the public through the media. But does not include either House of Parliament or a person exercising functions in connection with proceedings in Parliament. So the DEFRA personnel and the VAT and others are not covered by any exemption from this obligation. And this is describing what the definition and interpretation, etc., explanations. An act includes a failure to act, but does not include a failure to introduce in or lay before Parliament a proposal for legislation. It doesn't apply because we are not talking about legislation. And a failure to make any primary legislation or remedial order. It doesn't apply here. So the 1998 Act, this has got a lot of content. Okay, so this one is saying judicial remedies in relation to any act or proposed act of a public authority which the court finds is or would be unlawful, it may grant such relief or remedy or make such order within its powers as it considers just and appropriate. Now, this is the critical description. If the court finds, which the court finds unlawful, but that is not applicable because the court itself is behaving illegally, unlawfully, prejudicially, ignorantly. It's a grave allegation against the court. Proceedings under Section 7(1)(a) in respect of a judicial act may be brought only by exercising a right of appeal on an application for judicial review or in such other forum as may be prescribed by rules. That does not affect any rule of law which prevents a court from being the subject of judicial review. So there is, again, I'm reading this about judicial review. In proceedings under this act in respect of a judicial act done in good faith, damages may not be awarded otherwise than to compensate a person to the extent required by Article 5.5 of the Convention, or to compensate a person for a judicial act that is incompatible with Article 6 of the Convention. Now, you can see that all of these are matters of details that the court, county court, court of appeal, any division of the high court must be aware of. And once the reference is made to the 1998 Act, that should serve as the beginning, as a summary citation of the reason for the application. My suggestion, my advice is not about the details. Remember what I'm saying. Mass applications to various courts, to the county court, to the high court. If the high court is the only one where the application can be made, then the high court should be flooded with applications. If the court of appeal is to be made the court, destination court for the applications, then the court of appeal must be flooded with applications. The point is to flood the existing English court system with applications on behalf of Helen and or by Helen, either Helen individually or Helen plus any number of supporters, 10 supporters, 20 supporters, 30 supporters, even Helen and another supporter. It doesn't matter how many. These persons are entitled to apply to the courts. And the worst that the court can do, or the courts can do, is to say no, create an obstruction, which then creates a ground for that court to be sued separately. So instead of sending pleas for mercy to Boris Johnson or George Eustace, a mass submission of petitions, applications to the courts will have a more powerful impact on DEFRA and on the wrongdoing, non-compliant judges like Mary Stacey. Mary Stacey can be sued criminally in her own wrongs because she made criminal abuse. She criminally abused her position yesterday and insulted Helen MacDonald and her lawyer by suggesting that they were vague. They were vague. They were not vague. I mean, nothing could be further from the truth. Helen has been actively campaigning against DEFRA's lies, secrecy, falsehood for 4 years. This is not vague. And everything Helen has told DEFRA is absolutely clear that Geronimo, far from being unwell, far from being infected, Geronimo has been a perfectly healthy boy. Quite apart from the fact that Geronimo is not likely to come in contact with cattle, other animals, whatever. Geronimo has been in a quarantine of his own, in his own farm. So everything that has happened and everything that Helen has done and has been done on her behalf in procedural forums, has been absolutely the opposite of vague. It has been clear and it has been absolutely crystal clear, fact-based, evidence-based, science-based. As all the people that have been commenting publicly and supporting Helen and supporting Geronimo have been justifying and have been kind of including evidence-based grounds and reasons for opposing DEFRA. So Mary Stacey showed yesterday the serious fundamental weakness in English judiciary and English High Court, because this person is quite literally very ignorant. And she lacks compassion, and she lacks judgment, she lacks morality, ethics, and a commitment to uphold the law. When she was recorded in 2017, not long after experiencing her first judicial experience of sitting as a judge, whatever level, she said that she was excited, or she was thrilled, or she was interested to find that when she sat as a judge, or she would be sitting as a judge, she would not have to behave in a partisan way any longer. Now, this is 4 years before she did that. That was 2017. 2017 is the year, also coincidentally, in which Geronimo arrived in the UK from New Zealand, where he was bred by his original mom, human mom, Leonie Walker, and her husband, Neville Walker. And as Leonie Walker has told the Times of London, she was very sad for Geronimo to leave. How poignant, how telling that particular sentence is. Because Geronimo comes from a very healthy family of alpacas. Well loved, well looked after, and that family has not had any disease for 20 years. And when Geronimo was tested as part of the kind of procedure, let's say, shortly before he left New Zealand on his way to Helen, he tested negative. Now, he has not been tested on arrival. He has not been truthfully tested, honestly tested, properly scientifically tested at all. What did happen after Geronimo arrived in England, Geronimo was subjected to the ongoing corrupt regime operated by DEFRA as part of its agenda to destroy perfectly healthy animals. Why? Because that gives the appearance of DEFRA doing their job to safeguard the safety of the majority of the animals. But Geronimo was not tested. Geronimo was abused, misused, and was primed with a lot of false elements, and all the falsehood and lies and grooming and injecting was intended to produce a misleading, false outcome of the test, which is what happened. It's like injecting a perfectly healthy person with whatever substance can technically be used to inject them, if that person has been already targeted for producing a result that would be used or usable to destroy them. That's what has happened. And as that has happened, Helen has searched far and wide, and Helen has consulted any number of people with experience of similar kind of behavior by the DEFRA. And so far as we can access, the evidence that she has found has confirmed what Helen has been treated with, how Helen has been treated. The DEFRA has been running a criminal regime under the guise of testing, which is the secret why DEFRA doesn't want to allow Geronimo to be tested again for the first time properly, because they know that Geronimo is well and Geronimo would pose no health risk or threat, that Geronimo would produce a negative. That is the battle in the courts. And that is what the mainly Birmingham-based solicitor, licensed law trading solicitor, who has been given a judicial post, as I said, 2017 is the same year she got that video in which she boasted that she no longer had to behave in a partisan way. Now, the fact that this woman is a liar is proven in the facts of what she said yesterday. Her attacks on Helen, her attacks on Geronimo, her attacks on the behavior and the approach and the tactics of Helen's licensed law trading lawyer, a woman called McGahey, who is now carrying a tag QC. The way Mary Stacy condemned Geronimo, condemned Helen, and condemned McGahey shows that Mary Stacy doesn't know anything other than being partisan. She was totally partisan for DEFRA. She is partisan against the truth. She is partisan against the evidence. These are the grounds that can be advocated in the applications to the county court if they accept, and to the High Court, Court of Appeal, Supreme Court. There is absolutely nothing illegal in asking any of the courts through an application for permission to have the claim heard against Mary Stacy, against DEFRA, and against anybody else who has been colluding. So, what is unprecedented in this? Because this has been, as far as we know, this has not been done. So I'm devising an unique constitutional law approach to protecting Geronimo from the plot from murder and for upholding Helen McDonald's rights, human rights that have been intentionally, deliberately, knowingly, illegally, criminally violated by DEFRA. So let's go to some of the other references that are needed in this. This is not showing the correct time. So let's look at the correct time there. So let's just show the time there. So let's say it started about 1550 hours GMT, that is 1650 hours UK time. So let's change the time. So I'm changing the time at 16:15 hours GMT. And so we have been on this broadcast for about 25 minutes. So let's look at the application forms. All right, so this is the this is the page about human rights act that I'm looking at on the internet. It says, who does the Human Rights Act apply to? And the answer lists these: government departments, courts and tribunals, local authorities, police, prison and immigration officers, schools, if publicly funded, the ombudsman, public prosecutors, NHS trusts, health boards and hospitals, and there are other items. Private organizations or charities that carry out public functions could include, for example, privatized utilities like water companies, British Gas and Network Rail, a security company running a private prison, housing associations that act as social landlords, private care homes providing care on behalf of a local authority, and private hospitals providing care on behalf of the NHS. And if you think you might have been treated unfairly and want further advice, you can contact the Equality Advisory and Support Service. Now, the Equality Advisory and Support Service is open from 9 a.m. to 7 p.m. on Monday to Friday and 10 a.m. to 2 p.m. on Saturday, closed on Sundays and bank holidays. And this is the website in one word: equalityhumanrights.com. So it's a one word spelling. So let's look at the other details. I'm doing this for Helen. You can watch this and you can easily rewind and you can see what I'm saying. And this is a website, equalityhumanrights.com. It's Equality and Human Rights Commission. So look up Equality and Human Rights Commission. Now, we have in the last few days referred to David Neuberger. Neuberger was the president, the first president of the UK Supreme Court in January 2017, when he read out on behalf of the entirety of the Supreme Court the contents of the ruling by the Supreme Court that was against the UK government, not against the UK government in place at the time, but UK government that was represented in the early 2000s, when the Libyan dissident against then Libyan president Muammar Gaddafi, a man called Belhaj, and his wife were kidnapped from locations in Southeast Asia, maybe Malaysia and Thailand, and they were kidnapped by the CIA and they were treated as targets of torture that went on during the flight from Southeast Asia to the address in Libya. Now, at that time, 2004, I think, the Libyan president Gaddafi was still alive, and the UK had Prime Minister Tony Blair. And Tony Blair was, as the wiki entry says, was wooing Gaddafi for money or whatever. And at that time, these victims of torture by the CIA and the torture colluded in by the UK spying agencies took place. So this case took many years, and the Belhaj case, Belhaj and another versus Straw and another. Straw was the UK's foreign minister. So the ruling was published on the 17th of January 2017, the calendar year, like Mary Stacey's video was in 2017, the very year that Geronimo was said goodbye to by Leonie Walker, and Geronimo arrived in England 2017. Now, this is the case in which the 1225, let's check the actual date of the Magna Carta. The Magna Carta, let's check if we can find the Magna Carta. Remember, you can always wind back and look at what I've been saying, so you are not missing anything. Okay, so the Belhaj case. All right, the judgment I've been talking about is described there as Hillary Town, 2017, secondary quotes, brackets, and then UK SC, that is UK Supreme Court 3. It was an appeal from 2014 EWCA SIB 1394 and is accessible by 2014 EWHC 3846 QB, that is Queen's Bench Division. Now, the Queen's Bench Division is a division of the High Court, and it is the most populous, overloaded division. Shall come to the Queen's Bench Division in due course. So this judgment is headed Belhaj and another, that is the respondents, because this is an appeal by Straw and others, appellants, and Rahmatullah number 1, respondent, versus the Ministry of Defense and another appellants. And it was before the following listed judges in the Supreme Court: Neuberger, President; Hale, Deputy President; Mance, M-A-N-C-E; Clark; Wilson; Sumption. Sumption is the one who has been hitting some of the headlines from time to time as a side career in his status as an ex-judge of the Supreme Court. Now, it's a judgment given on 17 January 2017. And the case was heard on the 9th and 10th and 11th and 12th of November 2015. So you can see 2 years before the actual judgment was published. And it has got all kinds of listed licensed law traders. And there were interveners: International Commission of Jurists, Justice, Amnesty International, Redress. Was it read by Lord Mance or was it read by David Neuberger? I correct myself if it was read by, quote, Lord Mance. Table of contents. Guess the contents. The claimant's allegations, that is, summary of conclusions, state immunity, foreign act of state, 3 types of foreign acts of act of state, analysis of the case law, Carr versus Francis Tynes, the United States authorities, Butts, Guess versus Hammer, application of the first and second types of foreign act of state, application of third type of foreign act of state, miscellaneous points, overall conclusions. The appeals now before the Supreme Court in Belhaj and Bodh Shah, that is the last name of his wife, Belhaj's wife, against Straw and Ministry of Defense versus Rahmatullah concerned the alleged complicity of United Kingdom authorities and officials in various torts. Tort is a civil wrong as opposed to a criminal wrong. So the torts allegedly committed by various other states in various overseas jurisdictions. The torts alleged include unlawful detention and rendition, torture or cruel and inhuman treatment and assault. Now, these are the titles on which Helen can be making the application because she has been treated with cruelty and inhuman treatment. And this is the part of the claim that she can make against DEFRA, against his agents, against anybody else that has been complicit. Because this is not about the proceedings in Parliament, so she can do that. She can make the claim. And I shall come to the Magna Carta, where the Magna Carta is referred to by the Supreme Court ruling, let's say. And there are factual references to ill treatment of the original claimants, Belhaj and his wife. These are referred to. Now, in paragraph 98 of that ruling, I'll read the introduction of that in that paragraph 98. The critical point in my view is the nature and seriousness of the misconduct alleged in both cases before the Supreme Court, at however high a level it may have been authorized. Act of state is and remains essentially a domestic law doctrine, and it is English law which sets its limits. English law recognizes the existence of fundamental rights, some long-standing, others more recently developed. Among the most long-standing and fundamental are those represented in Magna Carta 1225, Article 29, which reads, and this is the quotation from that part of the Magna Carta, or that edition, Article 29 of the Magna Carta of 1225. No free man shall be taken or imprisoned or dispossessed. Now this is the bit. Dispossessed is the one that applies to Helen. Of his liberties, or be outlawed or exiled or in any way destroyed, nor will we, that is society, English society, condemn him, nor will we commit him to prison. Because Helen has been told, threatened that she would be sent to jail. She'll be, if she does anything to expose DEFRA's lies and protect Geronimo. So reading this again. No free man shall be taken or imprisoned or dispossessed of his liberties. There are other aspects that are not included in this quotation. Or be outlawed or exiled or in any way destroyed. Nor will we condemn him, nor will we commit him to prison, accepting by the legal judgment of his peers, not the illegal, idiotic utterances of Mary Stacy, as she did yesterday. Accepting by the legal judgment of his peers or by the laws of the land. The laws of the land remain untested because the behavior of Mary Stacy and the previous judges combined has been contrary to the objectivity, unbiased nature of the law of the land. To none will we sell, to none will we deny, to none will we delay right or justice. Now, this is something that applies to Helen MacDonald and the way that she has been treated. And as I said, this is Magna Carta 1225, Article 29. And the Magna Carta 1225, 1325, 1425, 1525, 1625, 1725, 1825, 1925, and 2025. So it's almost 800 years. The fact that the Supreme Court had to refer to that and quote that also exposes the lack of exercise of human rights and the concept of justice through the English court system, bureaucracies, over 800 years. So I'm saying to the people who support Helen MacDonald, as well as support Geronimo, that there is nothing to stop them, prevent them from applying to the courts themselves, and the application can be made severally, that is, separately and collectively with Helen. And that is something that the application can be based on the 800-year-old undertaking by the state to deliver justice and fairness to the citizen. Anyone who is not clear can read the whole thing. And what happens is that this broadcast, we publish the transcription not many hours after the broadcast. So we shall put the transcription as well, the transcript, online, so that anyone interested can check and recheck what I'm saying. This is not a specific kind of completed form of application. This is a general guideline making it very clear that Helen has been denied her human rights. The way she has spoken, I'm looking for the page in the Daily Mail today. It actually gives the kind of flavor of how she has said that she and Geronimo have been treated appallingly by DEFRA. The direct contact has not been with Boris Johnson. Indeed, nor with his father Stanley Johnson. Shall come to Stanley Johnson and Boris Johnson in a minute. Now, Anyone watching the Khoodeelaar television channel for the first time needs to know this. We call it the world exclusive diagnosis. The world exclusive diagnosis of Fleet Street. Now, Fleet Street is the collective name of the Daily Mail. I'm going to find the Daily Mail online and see if we can have a look at what Helen has said. As reported in the, well, there are two of the Fleet Street papers, the Sun and the Daily Mail, carry anything that is not noticeable about Geronimo and about the murderous utterances by Mary Stacey yesterday. Okay. On page 14 of the Daily Mail, let's see the page 14 of the Daily Mail. Geronimo and Helen are featured. So that's the page 14 of the Daily Mail. Okay, so the Daily Mail today, Thursday the 19th of August 2029. Okay, so she says in the first column, I'm not the sort of person who cries easily, but I am shedding tears now, she said. I've had to stay strong to get through this battle, which has been hugely personal. Although I have a great legal team behind me and the support of thousands of animal lovers the world over, it is still an intensely lonely place. I'm still not prepared to back down, and I'm determined the fight will go on to save Geronimo. But it's difficult at the moment to see where we go from here. Defra has sought to ride roughshod over me, but I'm a fighter, and if I see an injustice, I will fight to the bitter end. And believe me, there has been an injustice in Geronimo's case. Now that's the piece. Now we are doing the broadcast. This minute is 1640 hours GMT. We don't know what DEFRA has been up to, whether they have been desperate to murder Geronimo today. Now, there is a post in the Daily Mail website on this shows it was 53 minutes ago, and it said Geronimo could be killed from 4:30 p.m. today. So this item was updated at 15:47 hours today, and it is headed "Knocking on Heaven's Door. Geronimo the alpaca awaits his fate after owner lost High Court battle save TB infected pet." Now they put the quotation marks on TB infected pet for the first time. They didn't do that. Most of the items they have repeated without any quotation. They claim that DEFRA prefers. And as they say, as government bet is due on farm to deliver fatal blow today. And there are five people pictured on a farm standing with banner. Science not stupid. Alpaca Liberation Front. And there is a video about Geronimo after yesterday's stupid. Now this is a healthy boy. Absolutely brilliant. So there are many videos of Helen with Geronimo speaking to the media. And the comment says that they should have at least done the retest. What the meaning is that Geronimo's owner has always condemned the DEFRA lying because the test was false. And it's not just Helen saying that, it's many other people with both experience of alpacas and other animals being wrongly tested have supported her. So there is, on no aspect of the facts, is there any evidence that DEFRA is justified, nor indeed is any of the judges is justified. So the application, we go back to the application and come to the form. People can do this while they are also supporting Helen and Geronimo in and near the farm. They can do this. They can make calls. They can make comments online on the court's websites and court's Twitter feed and the government's DEFRA's Twitter feed, giving them notice that applications are about to be filed in county court and or in the High Court and or in the Court of Appeal and or in the Supreme Court. As I keep saying, don't be fooled, don't be deterred by what the professional license holding law traders say. There is nothing to be afraid of in going to the court. The worst the court can do is to say no. How is it any worse than what DEFRA is doing? So do this, and this will be the kind of measure of the weight and the burden on DEFRA and the wrongful court judges. I'm looking for the application form. Okay, so this is part 7. It's the So if you look up on the internet, let's say search engine, whatever search engine, part 7, how to start proceedings, the claim form. And it has got lists of claims against public bodies to be issued and heard, claims against where to start proceedings, claims against Welsh public bodies, and says particulars of claim. And it says particulars of claim must be contained in or served with the claim form, or subject to paragraph 2, be served on the defendant by the claimant within 14 days after service of the claim form. Particulars of claim must be served on the defendant no later than the latest time for serving a claim form. And this is all detailed in the website called justice.gov.uk, and then /courts/procedure -rules, and then it goes /civil/rules, particulars of. Now this is something that you can check, and if you got a printer, you can print the form. I'll come to the form. And method of service: first class post, document exchange, or other service which provides for delivery on the next business day. The best thing would be to take it personally to the court office and do it tomorrow. And there are provisions for extending the time for serving. Now, the main purpose of this is a campaigning constitutional law action, which is to flood the courts, county courts, let's say, with so many applications about the same thing that they will have to pay attention. Quite apart from the fact that they'll have to hear the claims. And if they don't grant the application for the claim against the government, the worst they can do is to say no. But there will have been by that time, huge pressure on the government in support of Geronimo and Helen. This is the other one, the Rupert Murdoch's own son, which is today's date, is the Thursday, the 19th of August, and there is a picture of Helen and the beloved Geronimo. So this is the way forward. If there is anyone that is not identified to us or not accessible to us, who is part of what Helen says, her legal team says that what we are advising will not work, they may be right. As I said, the worst that can happen is that the court will say no. But that's not the point we are making. We are making the point there are too many applications under the Human Rights Act and other violated rights that Helen has been entitled to but has been denied, that will make a huge difference in terms of the impact on the government. Now we shall come back to that because we have not yet shown the picture of the form, but part 1 application form. Shall we do that now before we go on to the other aspects? Let's say if we can find it. Part 7 is the part 7 of the civil procedure kind of rules in accordance to the civil procedure rules. And the form is called Form N1. And it says that you can make a claim in Form N, claim form CPR Part 1 Civil Procedure Rules, Part 7. And it says use Form N1 to make a claim against a person or organization. To settle a dispute include, okay, so then notes are included online. You can say N1A, N1C, N1D, and N1FD. And these documents are there. So you can find these documents. If we look at the government.gov website, www.gov.uk website, and go for the Form N1, N for Neil, no to Geronimo, no to DEFRA attacks on Helen and Geronimo. You go try the new online service for claims of 10,000 or less, claim for CPR Part 7 Form N1, notes for claimant on completing a claim form, that is N1A, and notes for claimant on completing a claim form, N1A. It's a large print, easy read version of notes for claimant, and there are lots and lots of guidance, and you can read them. Instead of just sending pleas and words of condemnation against DEFRA, you can start sending as part of the summary of the claim against DEFRA, that kind of thing, in the court. And as I said, the court's bureaucracies may say no, but if hundreds of people make the similar application and the court system says no, then the court system will be guilty of breaking the rights of the applicants under the Human Rights Act. And the connection between the claim and claimants and Geronimo is easily made. Geronimo, the treatment of Geronimo has been completely criminally negligent, and that negligent treatment has affected the welfare and well-being, mental health, and human rights of the applicant. Add anything else you feel in your experience justified. The human rights have been violated. So that is the N1 form. If you click, it will come up. And also, you can check the cost. And you can see the costs here. And you can look up Part 7 application costs. And it has got a long list of topics for application. And you can find and you can also, instead of calling it costs, you can call it court fees. Part 7 court fee. And so there are literally thousands of results, items, and you can choose which one, and it will give you the answer. And there is a free remission. Those who don't have the necessary level of income, they can apply for remission of fees, but that slightly delays the application. But I'm just pointing this out that is also available. Remission of fees under particular kind of amount of income. People who are pensioners can apply. And even if there are pensioners and they have to make an application by completing an additional fee remission form, then that can add to the weight in support of Geronimo. What I'm saying, therefore, is this, that far from producing any result from DEFRA in support of Geronimo, the pleas and the questions to them are diverting your time and energy away from making the court application in your own rights. The same applies to Helen. Same applies to Helen's supporters, Geronimo's supporters, and friends and well-wishers. So this is the time we are broadcasting. This is 2 minutes to 17. This is 16:58, 59 hours GMT, which is coming to the local time, coming to 1800 hours, 6 o'clock. So we have been broadcasting since, well, we've been broadcasting for about 1 hour and 10 minutes, so we shall continue. This is a special edition providing support from our campaign to everyone supporting Geronimo, everyone supporting Helen. And we have been doing this for the last 2 weeks, I think, in our particular comments, KhoodeelaarTV campaign. The KhoodeelaarTV campaign, I'll go into some details about that just for the understanding of the people who may not be familiar with us or me. My name is Muhammad Haque, and I organize the KhoodeelaarTV campaign as part of the movement defending the community in the East End of London. I am not doing this as part of any particular political party or faction or group or grouping. This is and has been and will always be entirely objectively based, founded on facts and evidence. And the concept is to seek justice and to oppose oppression, exploitation, denial of rights across the world wherever we are able to access any particular campaign. Helen's campaign we became aware of, and we became aware of the baby, Geronimo, as part of our ordinary kind of daily fact-checking. The minute we understood what this was about, we dedicated our time and resources, especially to support the campaign in any way we could. We are based in East London, and I have been advocating constitutional law rights and issues for a very long time. And as I say on the record, whoever is watching this may or may not want to accept what I'm saying, but they can check the facts. They may not like what I'm saying, the style I'm saying it in, but I ask them to think about the facts and the evidence. And the facts and the evidence in today's Britain shows that Geronimo is one of many victims of injustice. Helen is one of the many unjust acts and attacks by the UK state apparatus. Because imagine yourself, if you are a supporter of Helen, or you are somebody watching this, that you are not Helen herself. It has been 4 years that Helen has been struggling and fighting. Now, as a human being, imagine the suffering she has been caused, the pain she has been caused every single day of the uncertainty of the last 4 years. Now, the people who have spoken or spieled or spieled is the pronunciation, I suppose, about Afghanistan and against the Taliban, and in the UK House of Parliament or Houses of Parliament, against the current incumbent in the post of the President of the United States. They have been expressing all kinds of emotional words and phrases, suggesting, in summary, suggesting that the Taliban's behavior is the worst of the worst against innocent people, especially innocent people who have been friendly towards the occupying armies of the UK and the USA, and that a great betrayal has been perpetrated by Joe Biden and his administration. Words to that effect, which factually can be related to in the context of the UK and the USA's parts in the occupation of Afghanistan the last 20 years. And the most shocking aspect of the Taliban's behavior has been kind of shown on the UK media, especially on the online and printed version of Fleet Street, including allegations that the Taliban have been committing torture, murder, barbarity, and shooting people, focus being on the Taliban's atrocities against women, especially atrocities against women considered to be violating the Islamic code, and so on. And this has been correctly printed and posted online. What is the comparison between the Taliban and the UK's DEFRA department, which has been hell-bent on perpetrating serial crimes and cruelties against this English woman who has committed no crimes? In fact, she has been one of the most kind and considerate and caring human beings that has featured in the news for a very long time in this country, in the ordinary run of things. So how has such a kind person been treated by not the Taliban, but by the government fronted by Boris Johnson, who is particularly known for antagonism against the Muslims, against Islamic societies, Islamic culture, etc., etc. It's Boris Johnson's government, Boris Johnson's cabinet colleague, George Eustace, has been perpetrating the current or the last 2 years since Boris Johnson became prime minister, let's say. Eustace fronts the DEFRA department, and they have been persecuting this woman, torturing her, punishing her for caring for the evidence, caring for the truth. She is not breaking anybody's laws, and there is no law as far as the behavior, the recorded behavior of DEFRA is concerned. There is no law. There is no definition of due process that applies to the behavior of DEFRA. What is due process? Although there is a dispute about the actual application of the concept of due process to the UK, due process is an accepted central pillar of English law, British law, UK law. So here is the due process defined. This is from the Britannica.com. So for some reason, the page is not accessible because some other page is interfering. So we shall go to the entry, the Wikipedia entry on due process, let's say. All right, due process is described by Wikipedia entry on it as follows. Due process is the legal requirement that the state must respect all legal rights that are owed to a person. Due process balances the power of law of the land and protects the individual person from it. When a government harms a person without following the exact course of the law, this constitutes a due process violation, which offends the next concept, the rule of law. Now, you can look up due process entry on the Wikipedia website and you'll find this in detail. Neither Mary Stacey nor her predecessors sitting in the court playing at hearing Helen's application for Geronimo and for DEFRA to leave Geronimo alone, or for DEFRA to provide the evidence and to allow Helen to have Geronimo tested for the first time properly. They're all violating due process, quite apart from the violations of the particular acts of parliament. So the application to the county court or the court of appeal or the divisional court, any of the divisional courts, can include the grounds against DEFRA, against the judge, that they have violated due process, the requirements of due process. Because DEFRA is part of the state, the United Kingdom state. That can be included as particulars of claim. In the summary, you can say it, and then you can put in an additional sheet of paper or sheets of paper, either handwritten or typed. The handwriting should be very objectively legible. So typing is preferred. And the due process, the entry on due process, amazingly, has got reference to Magna Carta. Now, the reference to Magna Carta, Article 29 that we read from the judgment of the Supreme Court in the Belhaj case, delivered on the 17th of January 2017. Now, this one is in clause 39 of Magna Carta. It says, issued in 1215, John of England promised. This is the same quotation, probably a bit fuller than the one contained in the judgment of the Supreme Court in the Belhaj against Jack Straw case. No free man shall be seized or imprisoned or stripped of his rights or possessions or outlawed or exiled or deprived of his standing in any other way, nor will we proceed with force against him or deprived of his standing in any other way. Sorry, reading that again. No free man shall be seized or imprisoned or stripped of his rights or possessions or outlawed or exiled or deprived of his standing in any other way, nor will we proceed with force against him or send others to do so, except by the lawful judgment of his equals or by the law of the land. Now, this is the lawful judgment has not been available, that has not been provided, because the judges in series have refused to provide the law, to adhere to the law, and to deliver law. They have obstructed. They have effectively obstructed Helen's attempts to seek the judgment, proper judgment. Think about that. And you can go back and you can see what I've said. And it gives the history that the clause 39 of the Magna Carta of 1215 was subsequently issued by Britain, was renumbered, clause 29. The phrase due process of law first appeared in a statutory rendition of Magna Carta in 1354, more than 100 years later. But it is still 600 years ago. During the reign of Edward III of England, as follows, and it says, no man of what state or condition he be shall be put out of his lands or tenements, nor taken, nor disinherited, nor put to death without he be brought to answer by due process of law. And then it goes on in 1608, the English jurist Edward Coke wrote a treatise in which he discussed the meaning of Magna Carta. Coke explained that no man shall be deprived but by legem terra, the law of the land, that is, by the common law, statute, or custom of England. That is to speak it once and for all, by the due course and process of law. The words that Mary Stacy used intentionally insultingly against both Helen and Geronimo and against the lawyer appearing, the complete violation of that sacred guarantee, whatever the version, whatever the date of the particular edition of the Magna Carta, it still is a foundation that is instantly recognizable as a collection by the aware member of the public society. And the way that the courts have behaved has been repeating the criminality, the criminal violations of the rights that the citizen is entitled to under Magna Carta. Now we shall then go to the convention. Now there are conventions. Convention writes that Helen has been entitled to the rights that have been violated. And I have used the search term. Does ECHR still apply to the UK? And it says on the 12th of April, this answer is on the 12th of April, 2021. For now, the UK is still committed to adhering to its current commitments to human rights treaties and conventions internationally, including to the ECHR. And there are many kind of questions that you can find if you just type the search letters ECHR. It will produce a long list of answers. And there are answers that are short and there are answers that are long. And despite Brexit, the ECHR is still relevant. So what I'm saying is that don't let Brexit mislead you into thinking that the international treaties that the UK signed up to don't apply. There are various stages, various kind of degrees of defects that the UK state is vulnerable to be described as if it fails, dishonors, ignores the conventions. So the application should be flooding into the courts against DEFRA. And the applications may not need to flood. Helen herself individually can make an application. And it won't cost anything like the money that it has cost the previous cases, reportedly between 48,000 to 50,000 or whatever. The cases, Part 7 claims, can be made by Helen herself and by her supporters, dedicated supporters. And we have not even included the animal welfare legislation and the conventional rights that can be added. And Geronimo can, in effect, de facto, join the applicants and become part of the applicants against DEFRA. And the other point that I have not made, and I shall make now, is for Helen to bring an action in defamation against DEFRA, quite apart from the other things I've said, because she has been accused of lying. That is a defamation, without doubt. And they have been defaming her in print, in the newspaper pieces that they have been quoted as saying absolute untruths against Helen. She has been defamed. She has been defamed and libeled and slandered because the statements by DEFRA or statements on behalf of DEFRA as made to identifiable journalists identifiable members of Fleet Street and other parts of the so-called mainstream media are on the record. And there are grounds and evidence, grounds for an evidence of prima facie offense and wrongful claims against Helen. Traditionally, conventionally, she is entitled to claim in defamation, libels, slander, whatever. But she is also absolutely on the spot entitled under the 2013 Defamation Act, because she is absolutely having been caused losses. So she can seek damages depending on how much she has been caused to lose in cash terms or other terms. She can make really quantifiable amounts of claims against the DEFRA. And that can be only the beginning. Helen can also make an application under the Sex Discrimination Act. And again, this is accessible online. So I don't have to kind of elaborate on this. And there are other acts that she can actually cite as entitling her to make the application to the courts. None of the courts can deny her the applications just because Mary Stacey has said that all Helen is seeking is going by or through the back door. She is not. As I said, she can sue for defamation. Plain and simple. She can add Mary Stacey as a co-defendant in the action. Because so far as we have seen, she has been the most foul liar against Geronimo and against Helen and against Catherine McGahey, the licensed law trading barrister who appeared before Helen, Mary Stacey on Wednesday, the 18th of August, 2021. So these are the beginnings of the advice. And I would suggest that there should be at least a couple of people, if not hundreds of people, standing up to DEFRA by the court system, open. So we shall put this edition to an end at 17:25 hours UK time on Thursday, the 19th of August. And we shall continue in later editions. And as I say about the transcript, we shall check the transcript and there will be extract, but that watching this program should be quite accessible. I don't think it's been difficult to follow what I've been saying. And with the best of luck, absolutely best of luck and solidarity with Geronimo and Helen.